So let's talk about, so like I said, in the on the presentation, we'll talk about estate planning and the 3 reasons that encompass what estate planning is. So let's talk about my company. I am with NetLaw, and NetLaw is a do-it-yourself product. We are an online technology company that was created out of an estate planning law office group. Now, what we did at the law office is we served wealth clients. You needed a lot of money to come in and speak to one of our attorneys. But the great thing is you got your documents completed. That was what was really important. But really, we were only servicing a very small fraction of our community. What we wanted to do is we wanted to create something that got estate planning out to the masses, right? From all 50 states being covered. How do we get estate planning into the hands of everyone? And the easy answer was technology. So we created NetLaw, which is, again, a online do-it-yourself technology company for estate planning. We worked with attorneys in all 50 states to create this software. So when you do a NetLaw plan, you're getting the same exact documents you would get if you went to an attorney in your state. Why? Because the attorneys are all from your state, right? We have one in Texas, we have one in Virginia, we have one in all 50 states. And we used what they do to create our software. So again, using our technology, you get state-specific legal documents from your own state. We won the James Akeen Award from the American Bar Association. That award's given out each year to the company who has the best online delivery of legal documents. So we were very honored to have won that award. And again, if you're an IT company in the legal field, that's the award you want to win. Some of our major competitors like LegalZoom, Legal Shield, they haven't won that award, but we have. Again, the best online delivery of legal documents from the American Bar Association. Very important award. That led us to take this nationwide and use financial agents like Ravi or whoever invited you to this webinar to go in and introduce you to NetLaw and online estate planning. That's how we arrived here today. We only offer 5 plans. 90% of what we do is the second column. It's the premium probate avoidance package. That gets you every document that you're going to need. So I'm going to go over each of the documents and we'll talk a little bit about it and we'll go over why each document's important, right? So first document that you get, the last will and testament, right? Last will and testament. So when you talk about estate planning, everybody says will and trust, right? Do you have your will and trust? Well, the thing is, it sounds like it's one document, will and trust, but it's 2 documents, 2 totally separate documents. So let's talk about the first one, the will. There's 3 reasons you do a will. You name an executor. Who's going to be in charge when you pass away? Who's going to handle final expenses? Who's going to make sure that your assets get to the right beneficiaries? That's the role of an executor. Now, the executor can be someone here from the US or it can be someone from overseas. Now, I believe there's a couple states that say that your executor must be from the US. And I believe Texas is one of them. So you want to kind of be, read the document when you get it just to make sure, because it'll tell you. But, in most states, your executor can be someone from overseas or here in the US. And again, the executor, make sure that all of your final bills are paid, your taxes are paid, making sure that your assets get to the right individuals. That's the role of the executor. The second reason you do a will, if you have children under the age of 18, you need to name a guardian. If something happens to you and your spouse, who's going to raise your kids, right? So we need to go ahead and make sure that that's taken care of as well. And the third reason is making sure that we list our assets and who the beneficiaries are going to be, right? So that's the 3 reasons that we do the will. We also have a children's trust. If you want your children to receive their inheritance at age 18, if you happen to pass away, that'll happen. But a lot of people don't want their children to receive a big lump sum of money at age 18. Why? Because they may blow through it. They won't save it. They're not financially responsible enough to receive a lump sum of money. So you can string it out a little bit. Maybe you give a third of it at age 21. Maybe you give a third of it at age 25, and maybe the remainder at age 30. The percentages of how much you give them and the ages at which they receive it are totally up to you. You can decide when and how they get their payments. We also offer a durable financial power of attorney. Of course, we all know what our power of attorney is, right? Who's going to make our financial decisions for us if we're not able to? Maybe we're overseas, right? And we were trying to sell our house. The financial power of attorney can come in and help us sell our house for us. They can write bills for us, right? They can write a check for us. So it's a very important role that they offer. The next 3 documents I'm going to talk about are our healthcare documents. There's 3 of them. Healthcare surrogate, that's just like your financial power of attorney, except for medical decisions. If you're laid up in the hospital and you can't speak for yourself, who's going to speak for you? Who's going to know your wishes and make sure that those wishes are passed to the hospitals, the doctors? HIPAA authorization allows someone to see your medical charts, right? See your psychotherapy notes so that they can make an informed decision with the doctors, with the hospitals. And usually your HIPAA agent and your healthcare surrogate are usually the same person. Now they can be different, but usually it's the same person because they act so closely together. And then the last document for your healthcare is your advance directive. And it's called a living will in some states. That's your end of life decisions. Do you want to be hooked up to a machine, live as long as possible? Or do you just want to pass naturally when it's time? Totally up to you. It's your decisions. That you're going to hear that a lot from me as I do this presentation. Your decisions, right? We want to make sure that your decisions are taken care of. That's why we do these documents. We have a pet trust, right? So if you have a dog or cat or rabbit or anything like that, you can leave a little bit of money behind in case you pass away. Who's going to take care of that animal, right? So you can leave a little bit of money behind for vet bills, boarding, food, stuff like that. Because bringing on a pet, well, that's expensive. Vet bills are outrageous. And, you know, you can help them with the burden of bringing on more bills, right? So you can help them by leaving them a little bit of money. And the last document we're going to talk about, remember in the beginning, I talked about will and trust, right? We talked about the will. So let's go ahead and finish up with the trust. The best way that I can describe the trust is it's a holding document. It holds all of your major assets so that it avoids probate. Probate is the process where if you pass away without your assets in the trust, then your assets are frozen for a certain amount of time, usually anywhere from 30 to 180 days. That gives creditors time to come in and take what's owed to them, and then the rest of your assets are passed to your beneficiaries. Anything that you have in your trust passes automatically to your beneficiaries. It avoids the probate process. So that's why it's so important. And we're talking about major assets: homes, cars, vacation homes, boats, property overseas. You can fund that into this trust. So if you have property over in India, you can fund that into your US trust. So those are the documents that come with this. Then there's 3, I like to call them comes with, right? There's a vault system. It's a cloud storage vault system inside the Net Law Plan. There you can store all of your important documents, not just your estate planning documents, but deeds to houses, titles to cars, videos, pictures, passports, anything that you can download and store in there, you can do it. Has 100 gigabytes of data, so you should never run out of storage space. The spouse's plan is included as well. So both the husband and wife get to create their own separate documents. And we have a 30-day money-back guarantee. Try it out. If you don't like it, as long as you haven't downloaded your documents, we'll give you your money back. No questions asked. All of this for $600. In our law office in Louisville, Kentucky, this exact plan here is anywhere from $3,500 to $5,000 based on what attorney you talk to. Why is this so inexpensive? We've already paid the attorneys, right? The attorneys have already done the work. They've created the software. You just need to go in and answer the questions. So I think it's important to go back and say, for the trust, you can put your assets into the trust. Even if they're foreign assets, you can put those assets into the trust. And in the vault, we have funding instructions that explain how you do that. Your executor, your guardian, your successor trustees, they can be someone from the US, they can be someone from overseas. So always good to remember that you have options. Remember when I said, you know, and I really concentrated on the second column. We do have 4 other programs. Like I said, 90% of what we do is that second column. The only difference between the first and second column is that the first column does not include the revocable living trust, which is the probate avoidance. So you're getting a trust for $200. It's a great deal. The third column, for $750, you can get an irrevocable life insurance trust. If you have a lot of life insurance, and usually, you know, to make this a viable option, you need at least 5 to 10 million to start. But you can transfer those life insurance policies into the trust. And it does help out the beneficiary with taxes when they cash out. And then we have 2 starter packages, $99 plans. They cover the financial power of attorney and the 3 healthcare documents. These are designed for 18, 19-year-olds, right? They just became an adult. They're just getting started in the world. They probably don't have a house or a car. When they get that, they can upgrade later to the bigger plans. But at least this gets them started protecting their financial decisions and their medical decisions. The student package, as you can tell, has 1 extra document. It's the FERPA consent form for college. That form, the student signs, and it gives permission to the parents or guardian in case they're hurt, or in case the parent wants to call up and see how the student's grades are, how their conduct is. So we added the FERPA consent form for the student package. Now, all of these documents are revocable. That means you can go in and change them at any time except for the irrevocable life insurance trust. That is the only document that we offer that is irrevocable. That means you can't change it. But all of these documents are revocable. And you can go in and change your account at any time for the first year. The $600 plan, the $400 plan, you have 1 year to store as much information into your vault and to edit your documents at any time. After the first year, it's just $8 a month to continue. So $96 a year to have the ability to go in and edit your documents at any time. I created this slide to kind of give you a reason of why you would ever want to go in and edit your documents anyway, right? Because we don't think about that. We completed our documents, we're done. But I'll talk about a couple of them. I'm not going to go over all of them for time constraints, but you know, how about birth of a child, or maybe you adopted a child, or birth of a grandchild, right? We'll throw all of those together. Well, if you had your documents through an attorney, every time there was a new child that came around or a new grandchild, you got to go back to the attorney's office and add that grandchild, because you're probably going to leave them something. They're probably going to receive an asset, right? So you need to go back and see that attorney every time it happens. The great thing with the net law plan, you just log into your account, and you add them under the key people section. It's very easy. And then they're in your decision-making process, and you can leave them whatever you want. Same thing with relocation to a new state. If you had your estate planning documents through an attorney and you lived in North Carolina, but you got a new job in Kentucky, right? Well, you did your plan in North Carolina, but now you moved to Kentucky. Remember, each state has its own estate planning laws. That's why we worked with different attorneys in every state. So now you have to start over. You have to go see an attorney and pay another $35,000 to $5,000. If you have the net law program, you just log into your plan, you change your address, you upload your documents and reassemble them again, and you're done, right? Print out your documents, get them witnessed and notarized. That's all you need to do. So you can see the value of this. $8 a month to have the ability to go in and change your documents at any time. Well worth it. So I've talked a little bit about what net law is. I've talked a lot about what estate planning is, and I've talked about the documents that you get in the plans, right? So now I kind of want to bring home the point of why do you do estate planning, right? And there's 4 major reasons you really want to do estate planning. The first one is you decide who gets your assets. If you don't name your assets and the beneficiaries that will receive them, the state will come in to decide who gets your assets, right? So if you're like me, there's no way you're going to want the court system coming in and deciding anything like that. Even if you've promised something to someone, the court system comes in and makes all of that decision. So to make sure that your assets get to the right individuals, we do a will. Sticking with the court system making decisions, if you don't name a guardian for your minor children, the court system will decide who has custody of your kids. Scary, right? That's a scary thought. How do we avoid that? We name guardians for our children, right? If you have children under the age of 18, name a guardian. Name an alternate guardian. This will really cut down on the fighting between families too. Because if something happens to mom and dad and the kids are left alone, the mom side's going to fight over the kids, the dad side's going to fight over the kids. The custody battle is going to be terrible. And the kids are left in the middle, right? They've already lost their parents, and now everybody that they know are fighting over them. We can solve all of that just by doing a will and naming a guardian. So keeping the court system and keeping their decision makings out of who's going to raise our kids and who's going to get our assets, I think you agree with me. That's very, very important. Avoiding probate. If you've known anybody who's went through the probate process, and remember I talked a little bit about probate when I was talking about the trust. That's where the court system comes in and freezes your assets. Creditors come in and take what's owed to them first. Then what's left gets distributed to your beneficiaries. How do you avoid probate? Right? You do a trust. You fund your assets into the trust. And remember, even your property overseas can be funded into your U.S. trust. And lastly, our medical decisions. Isn't it important to have a medical power of attorney, right? That's our healthcare surrogate. The person who's going to speak for us if we can't speak for ourselves. And we're going to go ahead and let our family know about our living will, right? That's the end of life decisions. Do you want to live as long as possible through the help of artificial means? Or do you want to pass naturally when it's time, right? Your decisions. But it's great to let our loved ones know beforehand, right? Because if you don't tell them, they're not going to know your decisions. And no child ever wants to have to decide if they're going to pull the plug on mom and dad, right? No child should ever have to make that decision, or family member. So we ease their burden by making all of our decisions ahead of time, before we need them, right? This is why we do it before we need to do it. We do it now because we want to do it. Let's don't do it when we need to do it. So this is the last screen. And I've talked about pretty much everything that I wanted to talk about, but I really want to kind of focus in on why would I ever want to use net law, right? It's personal. Haven't I talked about that the whole presentation? Making sure that your decisions are taken care of. Naming your executor, naming your guardians, naming where your assets are going to go, right? This is a very conversational piece. Like I said, when we were talking about the healthcare decisions, let people know your decisions, right? Let them know that if something happens to me, I've already done my estate planning. I've already made the decisions. Let them know that they have a document that they can refer to. Give your executor a copy. Give your adult children a copy, right? Make sure that someone knows you did this because it's so important. Remember, we're digital. We're an online tech company, right? Your account is open 24/7. This isn't a law office where, we close on Fridays at 5 o'clock, right? Your account is open 24/7. You have access to it on your computer or on your phone 24/7. So if you need something on a Saturday night, you can do it. You can get it. And the last bullet point there is done, right? 60% of Americans don't have a will. 90% don't have all the documents that we offer in the $600 plan. This is exactly why we created NetLaw, because there's two reasons people don't do their estate planning. One, they don't like attorneys, and that's okay. And two, it's expensive. We've solved both issues. And remember, we won the James Keene Award from the American Bar Association that said that we had the best online delivery of legal documents. We hang our hat on that every day. That's our phone number and email address if you need to get a hold of us. But we always prefer that you call the financial agent that invited you to this webinar. Call them first. And if they need us, call us. We can help you go through your documents. We can help answer any questions that you have. We have all the information that you need. So Robbie, I'm going to turn it back to you. And hopefully as I was giving the presentation, some chats came in.
Yeah, thank you so much, Mark. And we have many queries already I can see in the chart. So we will just go with all the queries one by one, order by. The first one is there a sign-up link and what is the name of the attorney for Texas?
Well, Robbie, you would have the sign-up link. So if you,
Yeah, that sign-up link I have sent, but Urvashi, can you elaborate your question one more time? Like, are you referring to an attorney or you just need the sign-up link for the NetLaw? So you can unmute yourself and you can ask the question.
Yeah, and I can go ahead while he's doing that. I'll answer about the attorney. Inside the NetLaw plan, there's an attorney tab. You can click on the attorney tab, click the state that you live in, and then our attorneys in that state will pop up, and you can give them a call, you can email them, and they will talk to you. Yeah. But what we always suggest first is call us. We work with attorneys. Attorneys are in the office. Attorneys, if you call them, sometimes they'll charge you. We never charge. So it's always best to call us first. And it's a lot easier to get a hold of us than an attorney. And I believe, Robbie, that he's asking for your sign-up link so he can sign up for the plan.
Yeah, so I already sent my
okay,
link.
Good.
And the second question from Kasi, the fee is one time and lifelong, or do we need to pay the same fee every year?
Mm-hmm. No, so $600 covers you for the first year. That covers everything. If you want to continue after the first year, it's just $8 a month. Or that's an optional fee. You can cancel that fee. Now, if you cancel it, you do lose the ability to edit any documents or store anything else into your vault. The great thing is anything that was in your vault before you canceled is yours. You can go in there and print it out as many times as you want. And you can always come back. There's just a reinstatement fee. And no, you don't have to pay the $600 again. Our reinstatement fee is we charge $8 a month for however many months you were closed, but we capped that fee at $250. So if it was just 10 months and you needed to come back, all you'd owe is $80. But if it was 10 years down the road, all you would owe is $250. We're trying to keep this as affordable as possible for you.
Yeah. Thank you so much, Mark. And the next one is the Anup is asking, BOGO offer is still available, or at what time it is going to end?
Yeah, so the buy one, get one free offer is available till the end of April. So the way that works is someone pays $600 and buys their plan. Inside their plan, there's a claim BOGO button that they click, and they can put in the person's name, phone number, and email address of the person that they're going to give the free one to, right? Buy one, get one free.
Yeah.
But you have to, now I will say, you have to purchase it before April 30th, before the end of April 30th. But you have a year to give the free plan away. You have a year. You don't have to give the free plan away right away.
That helps. Thank you. And the next question from Uzair: is the trust protected from creditors like home lenders, credit card lenders, etc., and allows my beneficiary to get all assets and work with lenders themselves?
Yeah, so it won't protect you. This is not an asset protection trust. So, this doesn't protect you from anything except avoiding probate. It just takes those assets and it gives it to the beneficiaries right away. So it won't protect you from lawsuits. It won't do anything like that. What it will do is make sure that anything in this trust is private. So the creditors, so like your car, you can pass that right away. Your house, you can pass that right away. Because the trust owns it, not you.
And the next question from Arun: what is the difference between revocable and irrevocable trust?
Yeah, revocable means you can change it. You can go in and change your assets. You can add something, you can take it out. Irrevocable means once you create it, you can't go in and change it at all. You're stuck with it.
Okay. Property in India can be funded here.
Yes.
Can you elaborate?
So same way you would do your property here, the deed that you have for the property overseas will be transferred into your trust. So you would probably work with either an attorney in India, or if you have a family friend or family member that's still over there, they can go to the county clerk's office or wherever the deed is registered at. And what you're going to do is you're going to do a deed transfer over there, taking the deed out of your name and placing it into the name of your U.S. trust.
And the next question is, what if the executor is not available when the time comes?
Yeah, so there's alternates as well. So you name a main executor, and then you name alternates just for that exact reference. If they're unable to fulfill the role, then you have named someone else. And this is where we come into, if you're going to name someone overseas, right? It's probably a good idea to maybe name an alternate, someone here in the U.S. Same with your guardian, right? That way someone can go grab the child or children, keep them in their custody until the main person can get it from overseas to the U.S. to take custody of the children. Same with executors too.
Yeah. Is there a specific lawyer for Texas, and is there any additional cost to talk to them?
Is there any specific what?
Is there a specific attorney for Texas, and is there any additional cost?
Yeah, if you engage one of our network attorneys, a lot of them charge. That's why I always say, call us. Call us. We can answer 99% of your questions.
Okay.
But if you want to engage an attorney, that's great. I mean, that's what they're there for. You can just click on the attorney tab, click Texas, and some states, and I think Texas is one too, we have 2 or 3 attorneys that we work with there.
And the next question is, what about the money which they got from stocks trading?
What about the money from stocks?
So when the person earned the money from the stocks trading,
yeah.
Can we
Yeah, well, you wouldn't be able to put that into your trust, but you could put all of your stock stuff in specific bequest in the will.
Okay.
Yeah, because here's the difference. In your trust, you need to have a deed transfer or a title transfer, right? So, you know, homes, property, they have deeds. Cars have titles, right? Anything that has a named beneficiary would not be put into the trust, like life insurance, 401k, annuities. But it has to have a deed or a title. So like stocks would go in specific bequest. Gold would go into specific bequest. Gun collection would go into specific bequest. So, but in the trust, anything with a deed or title.
And how about the credit card and the debit card and all those?
I mean, I don't know how you would, I don't know what they're asking about a debit or credit card. You're not going to leave your debit card or credit card to someone. So I don't know what they're,
Okay.
I mean, if they're talking about bank accounts, maybe I'm not really sure what they're talking about.
Okay. And the next question from Yesh: if couple and key people all together were involved in an accident, how will anyone get to know about our will and trust ever existed, and who gets to claim our properties?
Right. So that's, remember when I talked about, let me go back to my screen here. Conversational, right? This is why we tell a lot of people that we did our estate planning. And, you know, if something happens to me and my spouse, this is where you go to get our documents. We've already done our documents. This is why you tell a lot of people, right? And then, you know, that, you know, who's going to do the assets? Well, that's why we name alternate executors too, right? So, you know, we can list more than one person. We can name one executor, and then we could name 3 or 4 alternate ones, right? So that someone, even if 2 or 3 people are on a camping trip and they pass away, right? There's always somebody who's going to be able to fill that role.
Okay.
And I don't know if I answered, there was a lot of questions in there, I think. So I hope I answered them all.
Yeah. And the next question from Nishit: when house is on trust and if we become bankrupt, then what is going to happen?
Well, if you become bankrupt, that's okay, because you still have assets, right? You probably still have a bank account. You know, you're going to get back on your feet. So, you know, you'll probably get a car again. I mean, you know, there's a lot of things you can do even if you file for bankruptcy. So just because you filed for bankruptcy doesn't mean that you can't do estate planning, especially for your healthcare decisions, right? Your will, if you have minor children, you still need the will to name a guardian. You're going to need to name an executor. You know, even if you file bankruptcy, someone's going to have to be in charge when you pass away. So just because you file bankruptcy doesn't mean that you can't do this. There's reason to do this.
They will not give
always.
Friends, families, grandparents, unless we have this document.
Okay.
It's a long process.
Mm-hmm.
Even that one also get, ultimately they will give, but for some period of time they have to stay in the foster care. So that's why it's very important.
Okay, why now? Why is this?
Can you mute yourself if you don't mind?
Why now?
Mm-hmm.
You know, Amma and I got certified for life insurance.
I don't know what that means.
You remember we went for
Okay, I muted everybody. So if you have a question, just unmute yourself and then ask the question.
Okay. So the next question, how is the trust going to protect my assets outside country if I don't have anyone to beneficiary who is going to protect it here?
Well, you'll protect. How's the trust going to? If you fund your property that's in a different country into your U.S. trust, then you're going to go ahead and have that in our trust, right? Is he saying that he has no one to give his assets to? I think that's what he's saying. You can always leave it to a charity. If there's no one to give it to, you can leave it to a charity. And then, you know, they could sell it and use the money for their charity if you don't have any beneficiaries to give your assets to.
Yeah. And the next one is, what is the difference between will and trust? Do I need to have both, or only will would serve the purpose?
Yeah, so you need both, in my opinion. If you own a house or a car and you want your beneficiaries to receive these assets right away, then you would need the trust. The will is important because you're naming a guardian, right? If you have minor children, you need a guardian. If you don't have minor children, then you don't worry about the guardian section. But you still need an executor, right? Who's going to handle everything when you pass? And in the will is where you list your assets and who's going to receive them. Remember, if you don't name that in the will, the court system will come in and decide who gets what. It's very important to have both.
Yeah. And the next question is the abroad bank accounts, like in India, they have bank accounts, they have stock account, they have brokerage accounts. So how can we do this?
Yeah, when you're dealing with brokerage accounts, you know, that's probably a good time to talk to one of those attorneys and ask them. They have a lot more experience dealing with brokerage accounts from other countries than I do. So I don't want to give anybody any kind of wrong answer. So that's when you would definitely want to pick up the phone and speak to one of our attorneys.
Yeah. So the next question is, do we need to nominate the guardian who should be an US citizen, or can I nominate somebody in overseas?
Right. So yeah, absolutely. You can nominate someone overseas if you want. You can nominate someone here, or both, right? You can name someone overseas to be the main guardian and someone here to be the alternate. So that always gives the alternate time to go, you know, grab custody of the kids before the main guardian who lives overseas can get over to the US and take custody of the kids.
And how can we include bank balances and CDs in US banks in trust? Is it possible?
No, because no one's going to know how much money you have down to the penny on the day that you die. So what you do is you just put the bank account information into the will and trust. And the best way to do that is, you know, for protection purposes, is just say that, you know, my Bank of America bank account number ending in 1234 goes to this person.
Yeah. Will there be any additional charges to do changes in the documents when we move from one state to another state?
If you're in the first year, no. $600 covers everything. If it's after the first year, you're either paying the $8 per month to keep your account open and active, or you can pay a reinstatement fee. And remember, that reinstatement fee is anywhere from $8 to $250.
Yeah. The next question is, what happens to the property if both parents pass away by accident without making a will? Does it not automatically pass to the children's?
No. That's why we do this. This is a whole lot different than over in India. When you do your will over in India, everything either gets passed to the spouse or down to the next generation, right? Your kids. It's not like that here in the US. That's why it's so important to do this here, because in the US, there's a legal term called intestate. That means you died without a will. And each state has their own intestate laws. So what they say is, if both parents pass away where does the house go? Well, it may go 25% to your brother, 25% to your sister, and 50% to your parents, right? Or 25%, or let's just say, or 50% to your mom and dad, 50% mom and dad, or next of kin. And it all depends on the state. Remember, each state has their own intestate laws, and you can read on them. All you got to do is just Google intestate laws of the state that you live in. It's eye-opening.
That's really good. And so one of the question from another member, Mark. So assume like a person has a house on the mortgage, and the house value is about 400K, and what had happened, he borrowed the loan for 400K, and the house value suddenly dropped from 400K to 300K. So the mortgage balance was 400K, but the house value dropped to 300K, and he has passed away, and thus his wife has to pay the remaining 100K to the mortgage company, or how it works?
Yeah, she would need to pay, you know, if her name's on the deed and on the mortgage, if they share the mortgage, then yeah, she's responsible.
Okay. Yeah, so that is a question from other member.
Okay. Good. That's a good question, but yeah.
And if anybody have any more questions, you can mute yourself and ask. You can unmute.
Hello. Hi, this is Rima. I have a question. The $600 that you have, is it per individual, or will it be like for me and my spouse that $600 applies for all those documents?
$600 covers both of you. So you
Okay.
get your set of documents, he gets his set of documents.
Okay.
What?
And then we get buy one, get one. So then if I gift one to my friend, then it'll be for her and her spouse, for example, right?
You're correct.
Okay.
So total you will get 4. You and your spouse and your
You'll be able to help 4 people. That's right.
And what is that $8 fee for a month?
That's after the first year, the $8 kicks in, which is optional, but it allows you to still continue to have your account open where you can go in and make changes at any time or keep storing stuff into your vault.
If I don't want it, then I will stop it. After a couple of years, then there is a need to update my document. So can I go and start from there, or how that is going to work?
Yeah, you would call us and we would just reactivate your account. We charge the $8 a month for however many months you were closed, but we cap that fee. The most you'll ever pay is $250 to reopen your account.
Oh, okay. Once I reopen, do I need to keep paying that $8, or just...
Yeah, it'll kick back in. So the $250, let's say you went 10 years and you paid the $250 to open your account back up. That covers you for a month. Then the next month, if you want to continue, you got to pay the $8 again or close it down again.
Okay.
So, quick question. If you relocate the family to India and say you don't have any assets here, but you're living there, this will get executed in US, or will that be based on the local laws?
No, yeah, if you move back to India, you're definitely going to want to do your will over there because these documents are only for US.
Okay, thank you.
So if in our document, if guardian is in India and they do not have visa or any official document to travel to US, then how will we get executed?
Yeah, so the executor can come in and if there's alternate guardians over here, the alternate guardian can control the custody. And what they'll do is if the main guardian wants the kids over there, they could put them on a plane and send them to India. And that's the way that they would get over there.
So based on the will, they cannot request for the visa in India to come to US and execute it?
Right. We're not going to provide they're going to have to get the visa on their own.
Okay.
So after...
my question is, what is the value in using the NetLaw online service instead of the Quicken Law Will Maker?
Well, there's a couple. I've heard of it, but I'm not too familiar with Quicken Willmaker. I think you have to compare apples to apples here, which I really can't do, but I'll tell you why you need to do ours. First, you get the full set of documents that were created by an attorney. I don't know who's created their documents. They could be state specific. They could not. They could be just a general document. Ours are all state specific, created by an attorney. Our program comes with a vault where you can store all of your important documents. I don't know if theirs does or not. We have a great customer service area that you can call, and we will help you walk through anything that you need to do. I don't know about their customer service. We won the James Keene Award from the American Bar Association. I know they haven't. We're the only one in estate planning that's ever won it.
So one question.
That kind of eases your mind on that.
So one question I had is, once we buy this package and we enter the details, at the end of it, is there like a registered a legal document that is made to us for our records, or how does it work?
Yeah, so once you go through the software, and the way that it is you go through a getting started process, and all of this is question and answers, right? The system asks you a question and you answer it. You go through a getting started process, you go through creating all of your documents, and at the end, you print them out and you get them witnessed and notarized. That's what makes them a legal document. And then what we highly suggest is you taking that witnessed and notarized copy and scanning it back up and keeping it into your vault. So you have your hard copy, and I think that's what you're asking, do I get a hard copy? So you get
Right.
your hard copy, and then you also have a digital copy that you scanned back in there.
Okay, so once that hard copy is signed by a witness, after that, is there any involvement from the authorities or any of the courts that is needed to kind of quote unquote register this?
Yeah, no. Once it's witnessed and notarized, that's a legal document. The only thing that will be recorded by the state is when you go to fund your assets into the trust. The county clerk's office will fund those recordings.
Okay.
What is the use of the vault? Suppose that, me and my spouse have the will and everything in your net law. We have the vault, we have stored the documents, but we both pass away. So who has the access to that vault then, and who knows that we have a vault where we have stored the documents?
Yeah, it's anybody that you want to tell. So your kids, maybe, your executor.
Do we have to give them the ID and the password for that?
If you want them to have access to your account, you would have to. Or you could say, call Net Law, and what we'll do is we'll talk to the executor. And the executor would need to provide us a death certificate. And then once we receive that, we will print out the documents and send it to them.
Okay, sounds good. Thank you.
Just to add, once you finish all your documentation, you need to take the printouts and you need to give to the executive guardians and everybody, the key people, and they will have your set of copies in the printout, which should be notarized. So everybody should have the notarized copies.
Right. Yeah, because if it's not a notarized copy, it's just a piece of paper.
Hi, this is Ram actually. Once we sign up for this net law, so all the documents and everything is done by you guys. These are legibly, so we live in Texas now, legibly allowed in any court of law in Texas.
That's right.
Or do we need to do anything?
That's right. These are the same exact documents you would get if you went and saw an attorney in your state.
Okay, the next question is, suppose if I write in my will, like I do have a home and I do have a couple of cars, and in my will itself I say, okay, this will go to this son and this go to my son. Still I need to put it in the trust.
You don't have to. The only reason you would put that in the trust is if you want them to receive the assets right away upon your passing. If not, they have to wait for the probate process to go through and then they'll receive them. So it's totally up to you on when do you want them to have that. If it doesn't matter, they can wait. You don't have to get the trust. You would get the $400 I would say 80% of our clients go with the $600 plan as opposed to the $400 plan. I'd say it's probably 90%. We don't sell a lot of the $400 plans because to get a trust for $200 is outrageously cheap. It's $1,500 just for the trust in our law office.
See, quick question. Once I create the will and trust, and say I decide no more changes,
Yeah.
will there be any dependency of the net law? Do I need to go through anything? Is it because I'm just trying to decouple? You know, every. Do I need to do anything through net law, or am I?
No, you can. The only thing that you would want to do is maybe call us and we can turn off the $8 for you. There's a place in your plan to do it, but a lot of people just call us to make sure that it gets done. That's the only thing you would need to do.
Okay. Just trying to make sure there are not additional dependencies.
No, yeah, good question.
Suppose that I don't want to make a trust right now because I've heard that living off of the trust, you have to do everything on it and it becomes very hard. And if I want to have a will in which I say, upon passing away, my executor needs to create a trust for my beneficiaries. So can we also state that they need to dispose of all our assets and cash it and put the cash in the trust? Can that be possible?
No, the executor cannot make a trust on your behalf. You have to make it for yourself. But
So
you could buy the $400 package now. Later on in life, you could upgrade $200 and get the trust.
So if suppose today we are making the trust, don't we have to transfer all the deeds, and isn't that a cumbersome process to do that?
No, it takes about 15 minutes. So all you do is you take the deed that you have to your property and the trust that you created with us. You go down to the county clerk's office and tell them that you want to do a deed change. And what they're going to do is they're going to create a new deed for your property in the name of the trust, not in your name. Really, it takes about 15 minutes.
And how much does it cost us usually to transfer deed?
I would say $200-300. I don't know. It's about 200 in Louisville. I'll tell you that. I don't know how much it is where you're at.
Okay.
Quick question. Is it clear? Is it that the reason to put any assets in a trust is that it would bypass the will primarily? Is that the reason to create a trust?
No, it doesn't bypass the will. It bypasses probate court.
Okay.
Yeah, Mark, in addition to the same questions, once trust is open, do I need to get the car title, house title on the name of the trust? In that case, does banks who provided mortgage and auto loan will accept the title change to trust?
Right, yes, yes. And this doesn't have anything to do with the mortgage. The mortgage still stays in your name. It's just we're taking the deed and doing the deed transfer or the title transfer from the car. And you have to remember, the reason they accept that is because you're the trustee of your trust. It's still under your name.
Will there be a recording available of the session?
Yes, I'm recording this.
Yeah, I will send it. And the last question, Mark, how many levels we can define in will as executor?
Yeah, you can name as many as you want. You know, the problem is when you start naming a lot, they all have to agree, right? Or there has to be a maximum. If you name 2 people, they have to agree. If you name 3, 2 out of 3 win. So you have to be careful when you start naming a lot of executors or guardians, you know, so it's totally up to you. You can list a lot of them, but remember when you do that, you know, it's going to be majority wins.
Hi, Mark. This is Shiva. I have a couple of questions. The first one is the NetLaw is an online tool where we are answering the questions. If I want the custom-based requirement, so which the NetLaw doesn't have the questions, so what should I do?
Yeah. What questions are you looking for?
I mean, I don't know the online questions that NetLaw is going to ask. If I want something like additional things that I need to add in the will or trust that the online is not providing, So some custom based questions. So what should I do?
Yeah. So you would call me or call our customer service and ask to speak to me, and I can help you get through that.
Okay. Second thing is, okay, again, because of this COVID, whatever. So how should we do that notarize?
Yeah. So right now we are working, and I'm hoping to have it up by the end of the month. We're working on an e-notarization process. So, because of course we didn't see this coming on, and then all of a sudden it was here. So we're working on something to help you guys out with that. But right now you would still just, you could go through your bank. I know a lot of banks are doing drive-through notary, where you just put it in the system and shoot it up through the little air thing, and they witness and notarize it inside the bank and send it back to you. Or you can
Mark.
just hang tight.
UPS also does the notary. UPS.
Mark, on that one, right? There is a notarize.com. They do this. I personally have done it myself in India.
Yeah.
It's like $50 or something.
That was actually one of the companies that we were speaking to.
Oh, okay. Is there any additional charges, Mark, once you talk to them and once everything is done?
Yeah, it'll be the same fees as what the notaries charge. So, depending on what the notary wants to charge, there'll be a charge to you to use it. But after COVID's over, I know a lot of the agents, the financial agents, were notaries themselves, and I know that they do that for their agents. You can always go to your bank. My bank notarizes all of my documents for free because I bank there. It's just right now we have to be really careful because no one wants to get this virus that's going on. So, but once it's over, there's a lot of options. But like I said, hopefully by the end of the month, we'll have e-notarization going on for you guys.
One last question, Mark, from Pearl. From Yash. He's asking that he spoke with one of your customer service agent, and they said you can still access even after 1 year. All his documents you can still access from NetLaw website even after 1 year. Is that true? Without paying $8?
There was one case that they brought to my attention where someone actually downloaded a document after they canceled their plan. And we sent that to IT to stop that. But I am not aware of any more cases that's happened on. Your account should be shut down. Because I tested my account, I closed it, tried to scan a document into it, and it wouldn't let me do it.
Okay, so what you are saying, once you are close your account after 1 year, if you have not extended your account, you cannot even open or you cannot even download in a read-only format also. Or you can.
It's read-only. You can print out. You just can't edit any of your documents or store anything into your vault.
Oh, okay, so what you are saying, read-only is possible even after we close the account.
Oh yeah, mm-hmm. You can still go into your documents and see them. You just can't print them.
Got it.
All
Mark,
right.
Israel, this Mark,
Yeah,
this is
yeah.
sorry, Ram. Once you provide all the list of accounts, bank accounts and assets and everything in the will and trust and everything, at the ending, is there any way we can write something? Okay, everything what is on my name or anything belongs to me. Leftover stuff can be, like after my pass away, so then it should go to my kids. So can we put a broader line like that so we should cover the rest of that?
Yeah, you don't have to do that. There's a section in the will called remaining property, and that does it for you.
Okay.